This presentation is available for MCLE self-study credit. If you would like to receive credit, you must take 3 actions. First, click the Show More text below on our YouTube page. The text will expand and show a link to download the handout materials. Once you finish watching this presentation, please click the quiz link to receive self-study credit. Once the quiz is successfully completed, you will receive a certificate via email within 72 hours. We hope you enjoy the presentation. Good afternoon, everyone. My name is Hayward Cho, and I'm the General Manager of ADR Services in Southern California. Thank you for joining us today for a presentation on mediation from the plaintiff and defense perspective, how to effectively work with your opponents to reach a successful resolution. And this presentation is presented by Mayra Fornos, Gretchen Nelson, and Edith Matthai. Before we jump into our program, I'd like to go over a couple of housekeeping items with you. First, your MCLE forms and handouts will be emailed to you by the end of this week. Second, if you have any questions, please enter them in the Q&A function below, and we will try to get to your questions if we have time at the end of the program. But if we do not, we will forward your questions to the presenters so they can answer them after the presentation. Now, I have the pleasure of introducing to you Mayra Fornos, who is the moderator of this program, and she will introduce Gretchen Nelson and Edith Matthai. Mayra Fornos is an accomplished litigator with 29 years of experience handling a wide range of civil matters with extensive experience in the fields of catastrophic personal injury, including spinal cord injuries and vehicular accidents, premises liability, products liability, elder abuse, wrongful death, medical malpractice, employment discrimination, ADA, business, general contract disputes, and family law. Ms. Fornos has received numerous awards and accolades for her advocacy. She has been listed in the best lawyers in America since 2011, super lawyer since 2012, and was named one of the top 50 women attorneys in Southern California. She is a recipient of the President's Award from the Consumer Attorneys Association of Los Angeles and was a finalist for the Advocate of the Year by the Women's Caucus of the Consumer Attorneys of California. In addition, she is a recipient of the Los Angeles Business Journal's Women's Making a Difference Award and was listed in the Los Angeles Magazine as one of LA's women leaders in the law. Mayra is a full-time neutral and available for your mediation needs. Passing it to you, Mayra.
Thank you, Hayward, and thank you, Lucy Barron and ADR Services for putting together this terrific and informative webinar. I am delighted to serve as your moderator and want to thank all of you for joining us today. And as Hayward mentioned, our topic for discussion is mediation from the plaintiff and defendant's perspective and how to effectively work with your opponents to reach a successful resolution. Our 2 panelists today really need no introduction. They are highly accomplished trial lawyers and litigators and are truly superstars in the legal field. Gretchen Nelson will be given the plaintiff's perspective, and Edith Matthai will be given the defense perspective on what you should do and not do during the pre-mediation stage, 2 during the actual mediation, and 3 after your mediation, post-mediation. So let me take a moment to give you a little background on these 2 preeminent attorneys that are going to share with you words of wisdom. Gretchen Nelson is a trial attorney and litigator and is a founding partner of Nelson and Fraenkel in Los Angeles. Her focus is on complex class action litigation involving securities, antitrust, business, employment, consumer tort claims, and represents victims of serious injuries, including aviation disasters and accidents on cruise ships. Gretchen has served on the Board of Trustees for the State Bar of California, becoming the organization's first treasurer. She is an emeritus member of the Board of Governors of the Consumer Attorneys of Los Angeles. She is a past president of Los Angeles County Bar Association and was chair of the litigation section. Gretchen has received numerous awards, both of these ladies have, and just too many to mention, including the Jim Robie Award from the Los Angeles County Bar Association, the Robert E. Hart Award, Senior Award from the Consumer Attorneys of California, and the Ted Horn Award from Consumer Attorneys of Los Angeles. In addition, Gretchen is an avid horseback rider and a member of the Cowboy Lawyers Association. Our second panelist is the incredible Edith Matthai. Edith is a trial lawyer and appellate lawyer at her firm, Robie and Matthai, and she has specialized in the representation of attorneys in malpractice actions for over 30 years, and also represents members of the Judiciary Committee. And she has handled matters arising from nearly every single field of practice, including complex business transactions, probate and complex family law proceedings, securities litigation, intellectual property litigation, and regularly defends malicious prosecution actions. Edith is a past president of the Los Angeles County Bar Association, sharing that in common with Gretchen, the California Defense Council, the Association of Southern California Defense Counsel, and also past president of the Los Angeles chapter of ABODA. Edith, again, has received numerous awards, too many to mention, including the Hall of Fame Award from the Association of Southern California Defense Counsel, the California ABODA Trial Lawyer of the Year Award, and the, oh boy, I had it written down, the Sheddick Price Award from the Los Angeles County Bar Association. Welcome, Edith and Gretchen. All right. So now we're going to hear from Gretchen and Edith about what you should do before your mediation to advance the possibility of settlement. So now we're in the pre-mediation stage that we're going to cover. And ladies, let's first start with the process of selecting a mediator. How do you go about selecting a mediator that both or all parties agree to? Gretchen, why don't you start?
Okay, well, there's a couple of different ways. Sometimes the defendant suggests them. There's sometimes a default belief that if the defendant suggests them, that they'll be listening to them. I'm not sure I agree with that. I think basically I try to work with the defendant to select a mediator that I think is going to be the right personality for the case. And that includes the right personality for what the issues are in the case, but also the clients. And it's hard for me to basically read what that means for the defendant because frequently it's an insurance adjuster or maybe a corporate in-house counsel. But certainly for my clients, I think it's really important to make sure you have the right mix of a mediator who is going to handle your client the best way.
That's right.
Edith?
Edith?
Yeah, I think the lesson from Gretchen, which I agree with 100%, is it's not one size fits all. I think you have to evaluate the personality and approach of the plaintiffs. If I'm evaluating the personality and approach of my opposing counsel, plaintiff's counsel, the personality and way that the plaintiff is going to handle the mediation. There are some plaintiffs who are very rational and businesslike. There are some plaintiffs who are anything but rational and businesslike. And different mediators have different abilities to deal with the ones who are totally irrational. So that makes a big difference in my choice. Also, I want to look at what the expertise is of the mediators. In some kinds of cases, it doesn't matter so much. But if I have a legal malpractice case coming out of family law or a securities matter or an IP matter, I'm probably going to want a mediator that has some knowledge and background, although I will tell you that there are other times when I decide I don't want somebody who knows the field because they're going to figure out the problems of my client.
That's good. So let me ask you this question, Edith. If a plaintiff requests to go to mediation, do you ever perceive it as a sign of weakness or that they do not feel comfortable or inexperienced to try the case? I know this is an issue that comes up.
I don't think so. Not at this point. When mediation was a new thing, and I'm old enough to remember that sometimes it was perceived as some sort of sign of weakness. At this point, particularly with COVID, when nobody can really get to trial, if somebody wants to get a case resolved, they're going to end up in a mediation. And I don't ever take it as weakness if a plaintiff says, hey, can we settle it? And I say it all the time. I mean, look, most of our clients want to get their cases resolved, and asking for mediation doesn't mean you're going to make a settlement that you're not willing to make.
Yeah, that's good. All right, what about the timing of the mediation? The decision when to mediate is very important. And what are your thoughts about early mediations or mediating a case before a lawsuit is filed?
Well, I'll jump in on that one. Mediating before a case is filed for me is always hard. That's dealing with adjusters. I don't really deal with them very well, having just been on the phone with one. I mean, some people are very adept at it, and if you are, go for it. I sort of take the view that filing the lawsuit means you mean business, and start going from there. I think the big issue that comes about for me is once you've filed the case, when do you sort of advance it? And quite frankly, in my humble opinion, it kind of depends upon the value of the case. If you really don't believe the case is a high value case, then you probably ought to get in and see if you can't get it resolved early on. If, on the other hand, you know this is a case that ultimately could result in a settlement that's easily in the small, low seven figures or the high seven figures, you're going to have to do a lot of work to get there. The defendant's just not going to turn that money away, in which case it's probably not worth doing anything unless you've put together enough of the discovery and you've gotten enough depositions so that you can make a strong argument that you've got a chance when you go to trial of getting that money. Edith?
Do you think going to early mediation may just open the door to start the negotiating process early on, especially if like liability is a given and the damages are within policy limits? Do you think that that's a good time to perhaps, try to go to a pre-litigation mediation?
Yeah, I think there probably is some merit to that. I mean, obviously there's this kind of fine line. If you have a case that's, potentially one where the insurance is, 100,000 and the case is worth more and the carrier doesn't think it. And so you're trying to kind of navigate your way through how the case will unfold and aspects of that. But I don't know, Edith, what are your thoughts on this? You're on the defense side. So to me, it's kind of more your game than our game.
Yeah, it's hard. I mean, there are some cases which cry out for it. I agree with you. If it's a low value case, you don't want to spend a bunch of money on it because that's going to be a problem for settlement on both sides if everybody has too much money already invested. But I've been a proponent of early mediation on many an occasion and have been very disappointed because sometimes it just takes a little bit of litigation to make one side or the other be more realistic about what the case is really about. And too often at the beginning of a case, a plaintiff can be incredibly gung-ho because they haven't seen the evidence that's on the other side. In my field, the problem is case within a case. And so often what will happen is the plaintiff's counsel will say that the lawyer's conduct is terrible and never get to that second layer of actually evaluating whether or not it made a difference. And sometimes for that reason, you've just got to do some litigation so that the information can come out that maybe it's not the block in the park they thought it was.
Yeah. So you need that time to go through discovery and get the information you need before making smart decisions. All right, so once you've decided when to mediate and you've selected your mediator, what pre-mediation communication do you recommend having with your mediator? And do you communicate privately with the mediator, or do you communicate jointly with your opposing counsel, or both, separately and jointly?
Well, what I've seen lately, and this is more of a, it seems to be a new thing that more mediators are doing, and I have embraced it wholeheartedly, where there will be a joint session early on before the actual mediation, where the mediator talks to both of the attorneys, sort of gets a sense overall about the case, where it's going, how far along it is. If anybody thinks there's more discovery that needs to be done, kind of gets a feel for the case, and then independently contacts and reaches out to the lawyers to have a private discussion with them about the process, and, you know, basically in confidence saying, you know, where do you think the weak parts are? What's your client like? I think it's very helpful for the mediator to get a handle on the client, because coming in cold, sometimes mediators can, with good meaning, I'm not trying to criticize, but have a sense of a client and take a position with the client that turns the client off. And then I'm just playing catch up, trying to forget the mediation. I'm just trying to get over the hurdle with the client over the mediator at that point, right? And why the heck did you choose this mediator? And you're like, okay, let's just see if we can focus on settling the case. So I do think that new convention that I'm seeing mediators do, I think it's extremely helpful.
And that was one of my questions. Do you share with the mediator the weaknesses of your case, or if you're having issues with your client or the opposing counsel at that point, or do you wait?
Oh, I do. I do. I'll be flat out, particularly if it's an individual. I'll be very blunt with a mediator and just say, you know, this is a client who has gone through a lot. There's a lot of issues here. You either need to treat her gently, kinder and gently is a better way to do that with this client, or no, this one needs a kick in the head a little bit, so I'm going to need some help from you. I absolutely do.
And that's very important, and to also bring any type of biases that may exist, you know, with the other side, or with even the mediator or the opposing counsel. What are your thoughts on this, Edith?
I think that pre-mediation communication with the mediator, whether it's jointly or separately, is very important, because otherwise you end up, first of all, you can get sideways without it. So I think what Gretchen said is very important. You can give the mediator some heads up about the issues that you're facing on your side, whether I may have a lawyer who's not consenting to settlement with an insurance company who wants to settle. There can be all kinds of different combinations. And if I can let the mediator know in advance some of the issues that are going to have to be, the practical problems that are going to have to be resolved, and the personality problems that are going to have to be resolved, it saves a lot of time at the mediation. And it also prevents something from going off sideways because the mediator didn't know that there was a particular sensitivity or a particular issue that was such a hot button for the client. We might not want to talk about it a lot, at least at the beginning. And I think that I think that it gives the mediator tools that they wouldn't otherwise have. So it's important.
Yeah, very, very, I agree. Very, very important to communicate with the mediator before the mediation, because you lay everything on the table, or a lot of things, and you already have jumped ahead to the negotiation process that they can help the mediator can help you with.
Yeah, I just have to interject here. I'm not nearly as forthcoming as Gretchen is. My least favorite question, I won't use a mediator who looks at me and says, okay, I want to know all the weak spots in your case. That would be no. Not telling you those.
Okay, all right.
I'm gonna weigh in on another thing. This is, I mean, I realize our audience is a mixture of, you know, lawyers trying to settle cases and mediators working to do that. I recently, I'm gonna just throw this out because I thought it was actually pretty great. I had a mediator call me who was having to mediate a very contentious case, and I wasn't involved in the case at all. But one of the lawyers was new to this mediator, and he knew I knew the person, and he called me to get a handle on what's this person like and how can I best work with him. So for those of you in the audience who are mediators, may I recommend that if you have a case where there's, that there are lawyers involved who may not be cozying up to each other and being very civil, you may want to reach out to other people to sort of get a handle on how best to handle the lawyers. Just a thought. He got the case settled, by the way. So
bravo.
Right.
Okay, so let's talk about mediation briefs. And I've handled some mediations where one of the parties drops the mediation brief the night before with voluminous records and attachments, or worse yet, doesn't even submit a brief. Can you please share your thoughts about the importance of submitting timely briefs to the mediator, and what to include and not include in these briefs, and what documents, or if it's best to summarize the documents in bullet points or expert thoughts and findings, and summarize that instead of attaching the whole expert or all the medical records. So ladies, please help us here.
Okay, Edith, you take this one because there's Gretchen meantime, which is always that I'm late.
I'm familiar with that.
In earlier years, I was probably more of an offender on this than I am now. I now have come to believe that if you can get a very good mediation brief to your mediator ahead of the deadline, before the other side gets their brief there, the mediator might read yours first. And that may anchor some ideas with the mediator that can be very helpful in the long run. I think you have to, again, this is not one size fits all. There are some mediators who are very prepared at mediations, and there are other mediators who are not. The ones who are not still may be somebody you want to use because they have other skills and talents, but they're not the person who's going to read every detail of your brief. On the other hand, there are mediators who really do rely on those briefs and study them completely. And for that group, you want to give them all the ammunition you can of all the reasons why they should view the case from your client's perspective. And I've been surprised at how effective it can be to do that.
I agree entirely. I'm probably the worst offender at this because invariably you're busy and you're scrambling. But I do think that it's important. You have to give the mediator something. You can't just leave them out there flailing on your case. And whatever you do, don't give them 2 pages that reads like there's 2 different cases. The defense brief says is one way and you're off on some other tangent. You have to kind of confront it. I think you spend more time on liability if you have liability issues. If you got damages that are pretty easy, you may not need to spend so much time on the damages. So you really have to pick and choose, but you have to kind of point out where you got to give the person some help. You can't just leave them floundering. And I do think exchanging them is good.
Yeah, and that was my next question. Yeah.
Yeah. If there's something in there that you don't want the mediator to pass on, I think you do that in a separate small letter or something.
I agree. I think it can be very effective to exchange and put anything, have a separate brief for your eyes only for the mediator if you need to. It saves so much time. If you start cold with a mediator at 9 or 10 o'clock in the morning and they don't know anything about a case, it's really unfair to the mediator because they have to try to figure out what it's about without having any advantage of being able to get some prequel for it. So all of this exchange of information can save time, which can be pretty important. It might get you out of there before midnight if you don't get to your first offer at 5 o'clock.
I agree with both of you.
Or at 5 o'clock, you're still at a spread that's 100 million and 100,000.
Yeah, no worries. We can get it done.
That's close enough, Gretchen.
Right.
So I actually recommend sharing briefs. If a confidential brief is submitted, the audience will only be the mediator and won't be seen by the decision makers, the adjusters that can see what's on the table and better promote negotiations and settlement. So please share your briefs. And if you have anything in confidence, just share that portion just with the mediator. All right, so let's move on how to prepare your client for the mediation. What meetings or conversations should counsel have with the client prior to the mediation to get them ready for it, and also to advise them what to expect at the mediation, that it's not an adversarial process, that it's a collaborative process, that, you know, you're trying to reach a mutually beneficial resolution. So how do you prepare your client for that?
Well, I think from my standpoint, most of my clients are pretty sophisticated, so they know what to expect at a mediation, but they also expect to be, particularly insurance carrier clients, expect not to have surprises in the mediation. Mm-hmm. So I'm most definitely going to be subject to criticism by my clients if we go into the mediation and all of a sudden the plaintiff comes up with a $2 million demand when my client is expecting them to come into the mediation at a fraction of that amount, or a claim of damages that hasn't been previously considered, some theory of the case that hasn't been previously considered. So I need to prepare my clients on what the issues are going to be, what the dollar damages are going to be, what I expect the plaintiff to do and not do in the mediation. I have clients who think that what we ought to do is we ought to decide in advance of the mediation what our open night, and they want to have a whole plan for the whole day. My crystal ball isn't that good. And so I basically tell people, look, this is a fluid process. We have to have a sense of where we want to end up. We want to know what our goal is. And then we go to a mediation and we adjust what we're doing in order to try to get to that goal. But you can't really plan it out step by step because it's a fluid process and you don't know what the other side's going to do.
Yeah, I think that this is, in my view, an area where a number of lawyers fail, not intentionally, but just don't appreciate it. And a significant amount of this really is dependent upon the type of the case. If you have a case that's basically an economic case that's, let's just say a consumer class action, dealing with the client before is probably not as important. But we do, particularly Stuart in my office does a huge number of aviation cases. And invariably when aluminum falls out of the sky, it's not a good thing for the people in the plane. And you are dealing with either catastrophic injuries or you're dealing with death. And wrongful death cases, you have got to spend time with your client before, because quite frankly, it is the area I've seen where people become so upset. Because in the end, what you have to understand is you're talking money about a person's life. And, we had a client not too long ago when we were going through this, and it was horrible on her because first off, it was Zoom. She's sitting at home. There's pictures of her husband who died in this hellacious crash surrounding her. And the mediator's talking about money. And we spent hours with her before, but even having done that, it was so hard on her. And so I can't urge people enough to spend time. And for the mediators out there, may I suggest you tell lawyers in the pre-mediation conferences you have, please discuss with your client some of these issues. And if there's anything that I as a mediator can do to help you navigate through it so that the person understands. I mean, in that particular case, the mediator was terrific in the end. He made one flaw, in my view, at the very beginning, which is he transmitted the first offer. He should never have done it. Because of course, it was a typical defense offer of, squat, right?
Watch what you say, Gretchen.
I'm sorry, it was one of those ones.
Now, we're supposed to be getting along here, working with your opponent.
Okay, I understand it. I understand. The case may be worth 10 million, but you got to start at 20,000.
I know. And you know what, Gretchen, that brings up a point that I think maybe even prior to the mediation, it's a good idea to reach out to the opposing counsel and to the and have them talk to the adjuster and also talk to the mediator about just the sensitivity. You know, sometimes when you do so many mediations and you adjust so many cases, it's like sometimes like doctors and lawyers that we lose a little bit of empathy. So to bring that empathy back into the negotiation and how the attorneys speak to the client that has had such a huge loss, whether it's a death or a severe injury, and for the mediator, how they can best, you know, just wrap their arms around the client, it really helps.
Yeah.
So thank you for bringing that up. Okay, so now we've graduated to the second part of this presentation, which is what do you do and don't do when you are at the actual mediation. So once you and your clients arrive at the mediation, whether in person or Zoom or in a hybrid scenario, the mediator will either have a joint session or will break into caucus. And so what are the pros and cons of both? And what do you believe to be the most beneficial for the various types of cases in today's climate?
Wow, this is
I'll leap in. You want to go ahead, Gretchen?
go for it, Edith.
Okay, so I think at this point, there are situations in which a joint session can be helpful, but you've really got to know who the people are that are involved. And I think it's something that can backfire if you've got Gretchen's client who is struggling with dealing with the death of her husband, and you have a defense lawyer that says something inconsiderate in a joint session, even if that wasn't intended to be inconsiderate, but it just is, because by the way, that happens. You can send things off in the wrong direction. On the other hand, there are times when I believe that the clients are not hearing some of the things that I believe would help get a case settled. And so I can say those in a joint session. And if it's done with some recognition of trying to make sure that I don't offend them, but I nevertheless communicate factual information that they need to know, a joint session can be very helpful to do that.
Yeah, I totally agree with Edith. This one is really, in my view, fact specific and not facts regarding the case. It's more fact specific regarding the clients and how best they can handle it. And some cases just absolutely joint session is out of the question. Don't even go there. Others, joint session can be very helpful. I mean, it can make a client understand the risks better. It can make a client understand the nature of the lawyer on the other side. I mean, I think those are important things. There are great trial lawyers, there's good trial lawyers, and there's not so good trial lawyers. And, you know, I think it's helpful if, particularly if you have a great trial lawyer on the other side, that your client understands that, you know, this is what you're going to go through if you go to trial. And if there's a way to get it resolved, it's probably better for you in the long run, because you're just not going to have to endure that 3 weeks, 4 weeks, 5 weeks of, you know, biting your nails the whole time. So, I mean, I think it really is dependent upon the case, and people have to be aware of that. If you don't know that, you might want to bring somebody else in on the case to help you.
Right.
You also have to know the opposing counsel, because there are some counsel who respond well to a dialogue about the case. And, you know, I had one guy who was just a hothead, and after I brought up some basic facts of the case, slammed this thing down and said, well, I didn't think you were here to defend the case. Oh, okay. This is a bad start. So you've got to know who you're dealing with.
Right.
And I mean, I remember the day where all mediation started with a joint session. Your opening, and sometimes it became so volatile that it was like, why are we doing this? And I mean, unless it's requested or it is beneficial, it seems like nowadays everything's just starting out just going to caucus. So
yeah, but I will say one thing about that, which is that I think Well, I'm not a big fan in most cases of that, the session at the beginning. I think there are many times in a mediation where, as a lawyer, I say to the mediator, okay, I need to talk to plaintiff's counsel. Let us just talk and start a dialogue at that point that may or may not involve clients. But it's often, if you just have the mediator going back and forth, sometimes there are places where you're better off as the lawyer to step in and have some direct communication with the lawyer on the other side.
Yeah, that can be very helpful. Very good. Okay, so now let's look at the experiences and stories, even war stories that you may have and can share regarding the best and or worst practices of how mediators that you have come across have conducted your mediations. And but before you get into that, we had a question submitted yesterday from an attendee that was very good. And her question reads, sometimes in a mediation, I have found that if I try to be reasonable in negotiations, the mediator will lean on me to compromise more than the other side. How can I both be reasonable and push back appropriately? That's an excellent question, because sometimes the attorney feels like the mediator's taking side or is wanting to just please the other side and really leans on someone, and the attorney actually doesn't feel right. So how do we answer this question? How can we help them with their actions?
Well, I'll say this, I feel like that a lot.
I know.
And I sometimes feel that because I'm on the plaintiff side all the time, that the mediator feels like it's easier for me to get my client to move than it is to get somebody who's writing a check to put more zeros at the end of the check. So I've felt that a lot. And I, quite frankly, am not sure I've really come to a good conclusion on that. I think my general sense of it is it goes back to selecting the mediator.
Mm-hmm.
It goes back to selecting a mediator who knows you and knows that you will try the case and knows that when you say no, you mean no. But if you are with somebody who you're new to and you feel that, I think the best thing to say is quit jumping on me. You got to make me feel as if you're doing the same thing to them. And if you're not doing the same thing to them, then we're not going to get anywhere on this. So
I think many times the mediator is doing that. They're putting pressure, just as much pressure on the other side.
I think that's right. I think you're right, Mayra. Absolutely. I think that, again, you bring into the mediation, as we all know, we bring everything. We bring all the baggage. We're all UPS stations, right? So you bring your own personal baggage into it, your own insecurities, your client's insecurities. You got everything going there, right? So you have to kind of set that aside and sometimes maybe say, okay, well, maybe that's not really happening, and sort of get a better sense of it. I mean, maybe what you do sometimes on that is what Edith just suggested, which is that I go out and just talk to the defense lawyer and get sort of a handle on it. Edith?
There's an element of this though that I feel sometimes, which really bothers me, which is that as fewer and fewer cases get tried and we come to a world where everything's going to get settled, then my concern is always that means that the biggest jerk always wins. Because if you're the person that sticks your feet in concrete and this case is going to have to settle, then the other side comes to you. And there's a point at which, when it's a reasonable compromise, that's fine. But there's a point at which it's not fine. And I think that you have to have your points that are reasonable, but nevertheless are okay. We're not going to go any farther than this. And I think one of the things that is one of my rules is that I'll never make a last best offer unless I have a client who will really do that. And those clients are about 1 in 1,000. Because I'm not gonna make a last best offer and then say, oh, well, how about a little more? That just doesn't work for me. To me, I've got to have credibility with the mediator. And if I say, this is where we'll go, and that's as far as we'll go, that has to be true. And you know, that's, and if it is true, a lot of times you can get things resolved once somebody believes, no, there isn't more to put on the table.
And credibility is so important with the mediator and with your opponent. I think. So, okay. So what strategies do you recommend when stumbling blocks come up? What do you do to bypass that, to jump those stumbling blocks, to keep the negotiation talks fertile?
Well, you don't go to a mediator's proposal 10 minutes after you started the mediation.
No, you gotta dance. You gotta do the dance, right?
Yeah. Yeah. I mean, I never understood that. I will tell you, has always been the hardest thing. I go into, you know, a store, and if the outfit cost X, I don't sit there and haggle about it. So I never fully understand this notion that, you know, you have to go through this game that has just sort of developed. But it's true, you do. You go through it for a couple of reasons. Everybody is learning during the process. So
that's right. And that's what's important, that, you know, during this dance, you're learning more about the interests of the other side. What's important to them? Do they need to save face? Do they really feel so wrong that maybe a stumbling block may be that they refuse to give an apology, or that, you know, they don't get reinstated at work, or whatever it may be. But what tools would you use on the mediator and on your opposing counsel to bypass, to crumble those stumbling blocks?
Well, I think you just hit on a point that I think is really important, which is to get a sense of what can be an important thing to the other side that may not be as important to you. So you get a differential value. So a war story, had a case many years ago, and we got to a stumbling block on the amount of money. And it seemed to be, we were at loggerheads, but somehow it came out that the plaintiff on the other side was really, really angry and felt that he had been, that my client had mistreated him and had not been polite enough to him. And we started a dialogue about that. And in the culture of the plaintiff, a bow was very, very important. Mm-hmm. And we went from negotiating about dollars to, believe it or not, negotiating what kind of a bow, because the cultures had there were various bows that meant different things. So we negotiated. Now my client would have curtsied 5 times, could have cared less about this, but it was very, very important to the plaintiff. And, you know, we ultimately ended up getting the case settled, and I sort of joked about it as being, you know, I mean, that bow took a lot of money out of that settlement, and yet it was what the plaintiff wanted.
Wow, very interesting, very interesting. Also, what I've seen is sometimes, you know, people sometimes are just genuinely just ignorant to some issues that are out there, what the different parties are experiencing, where they come from, what's their culture, what cave they were brought up in, you know. And so we need to become more aware of this diverse world that we have there, and really learn about the other side, put yourself in their shoes. And again, what's in it, what interest do they have? Because the mediation process is not adversarial. It's where you have to reach out, hold hands, and try to collaborate and come to solutions that's in the best interest of both kinds. So, Edith, that's just a check mark on that.
Yeah, I think, and I agree with Edith on this. I mean, I think a little bit of this also is driven by what the nature of the case is. Employment cases, in my view, are like family law cases. And you have to understand that a family, you know, family law cases, oh my God, don't even go there with me. You know, it's the one thing I refused ever to do, and I've steered clear of it since I started practicing. But employment cases are just like that. I mean, you spend as much time in your job as you do with your family sometimes. And then if you've been terminated, and you got to read, as a mediator, you got to be able to read between the lines. And as a lawyer in the case, you also have to be able to recognize the need to sort of address some of these underlying issues in those kinds of cases. And the same thing is true in, you know, in a wrongful death case, where first off, you might have multiple plaintiffs, each with different damages. And if you get hung up because one person says, why is that person's life worth more than my husband's life? You have to be able to come up with some creative ways to have the mediator work through those, because they can basically just stop it. I mean, if you come into that. So what are the solutions? I don't know. They're different for every case. You have to be able to be open to them. And I think that goes back to, why does it take so long?
Yeah. You have to be creative and open, yeah.
Right.
And entertain different possibilities.
Right.
So let's now look at a scenario where your client is digging their heels, either wanting much more money that's not on the table if they're the plaintiff, or they're the defendant, they're just not willing to give another dime. How do you work with your clients when they are not cooperating, when they are not understanding and are being unreasonable? Do you allow the mediator to talk directly to your client to see if they can nudge him or not?
For me, generally not. Because quite frankly, if you've lost that much control with your client, then I don't know how you're going to try the case with the client. But I think there's two things. The first is, there may be instances where you have a client who absolutely will not budge. And I went through this, and we had multiple MSCs. This was a case in Alameda that I ultimately tried. The defendant was willing to pay money that was real money, not all that he wanted, but it was real money. But he had a very firm view about what he thought was right. And he refused to budge. And then he got mad at me. And I finally thought to myself, I'm not going to get mad at him. That's his bottom. And if he wants to try the case and he knows all the risks, I'm at peace with that. I'll just try the case. So I think it goes to what Edith said earlier. Not all cases settle. Most do, but not all of them. So you need to be able to read your client. And if your client is not budging and you know your client has the guts to go forward with the trial, try it.
Yeah.
And if, on the other hand, you have a client who isn't going to do well in the trial and you know it, then you have to work with that client to navigate them through it. And depending on the mediator, I may actually let the mediator talk to the client, because the mediator may be able to bring some outside views to it that maybe the client is not listening to with me on. So those are my thoughts.
I think my answer to that is it depends on the mediator and it depends on the client. It's pretty darn rare for me to be in a situation where I don't, if my client has reached a stopping point, it's pretty rare for me not to agree to that. It's pretty rare for me to have a client that if I think they should go farther with the money, mostly that will happen. There are exceptions to that, but usually it's pretty rare to have a disagreement on that. So, you know, there are cases that, I mean, there are cases in which I agree with my client. We shouldn't pay any more money for this. Either the plaintiff's going to come to us and take what we're willing to pay or not. And if they don't, we'll try it.
Okay. All right. Okay, so now let's suppose that we get past the stumbling blocks with your clients, with opposing counsel, with the mediator, with the adjuster, and you settle the case at the mediation. Okay. What are your recommendations for documenting and solidifying the settlement, and what options are available with issues that may come up when the long form settlement is negotiated?
Document it at the settlement. whatever you do. And quite frankly, make it as simple and easy and as short as possible. And if you do want to do a long form settlement, you basically say right into it that the mediator gets back involved if there's disputes in the long form settlement. That's been my practice, and that always seems to work.
Okay.
Yeah, I want to
I'm
throw out a couple of things on this, because I think there are a couple of things. Number one, if it's a relatively simple settlement, one of the things you can do is take an agreement that has blanks for the dollar amount to the mediation. So you've got what you want ready to be used, and have someone younger than me with you who can fix it all up get it all fixed up and printed and all that sort of stuff. And ADR has facilities that you can link into, and so that's preferable. If you're going to do a simple agreement, okay. I think one of the most dangerous things lawyers do on a complicated case is mediate until 11:30 at night and then decide they're going to write a complex settlement agreement. I'm going to suggest to you that is a very, very bad idea. I have represented several lawyers who have attempted to do that in the midnight hour, and it's not turned out well. I think what you need, my recommendation is you have a very simple form. If it's going to be complicated, you have the basics on a piece of paper. You try to make sure all of those terms have already been discussed. You don't want to be asking for a confidentiality agreement for the first time after the mediation when you're doing a long form settlement agreement. You'd like to have all those things ironed out at the mediation. And then I think the most important thing is that you put pen to paper the very next day. And you try to have a good enough relationship with your opposing counsel that you can work out all of those stumbling blocks. And I absolutely agree with Gretchen that you give the mediator or someone authority to resolve any disputes on getting it finally documented or on the fine details.
That's right. And if you're on a Zoom mediation, ADR Services has, of course, DocuSign, which you can just do that online. So it's important that you don't walk out the door without getting something in writing. Okay. All right. So now we've reached to the last segment of the presentation, post-mediation. And so what do you do if the case doesn't settle at mediation? What steps should you take to keep the settlement discussions moving forward?
I think a little bit of this, I feel like all I'm saying is the answer to all these questions is it depends. Here's a couple of options. If the case didn't settle because there were real disputes about what the facts are and you need more discovery, you got to do the discovery and then start back up.
Mm-hmm.
If, on the other hand, you're past that and it didn't settle for another reason, I think this is what I do. I spend a lot of time post-mediation with the client, talking to the client about all of the issues that came up, certainly talking to the client about whatever the numbers were, also talking to the client about explaining what the risks are, what they would have to go through if they're going to try it, what the range of damages could be if you did try it, and gauge where the client is. And if the issue was that the client was at 100 million and the defendant was at $1 million, can you somehow or other navigate reaching in between that gap? And frequently you can. I mean, that's a huge gap, but there's got to be somewhere in between that you could try and resolve it. So I think I spend a lot of time with the client, and I actually do very much appreciate mediators who reach out immediately. Exactly. Not the mediator who 10 months later writes and says, "Hi, I still have this open. Did you resolve it?"
Yeah.
But the mediator who calls me the next day and says, "Okay, what happened? What can we do? How can we kind of get past this? What are some ways what can I do? What are some suggestions? Tell me what you think. I'll give you some suggestions," and then you work through it.
Very good, Gretchen. Edith? Anything you want to add?
I think it's talking to your client and getting a good understanding of, if you haven't got it already, by now you probably should have it, but you want to make sure you understand what the goal is. Is the client prepared to try this case? Do they want to try this case? Or is this a case that the client absolutely wants to settle and you've got to figure out how to get around the impasse? And those are two different approaches, obviously. If the desire is to continue to work to get it resolved, I think it's very helpful to pinpoint what issue is there that if you could get clarification in the case about that issue, would that change settlement possible? For instance, you can actually do a summary judgment on a discrete issue if you get everybody to agree to it and it's going to make a difference in settlement. So let's say you've got a statute of limitations issue. Maybe you can agree to bifurcate that off, try it, get it resolved some way, and that's going to take a big impediment out of whether or not you can get the case settled. So they're try to be creative about whether there's something that you can do that will, I call it the turn of the kaleidoscope. What is it you can do to turn that kaleidoscope to make the pieces fall in a different way that may enable you to get to the end? And if you can enlist your mediator to help in that, I always appreciate a mediator who's willing to do that.
Excellent answer, Judy. That was really good. That's very helpful. And last question. What if you have an issue with the mediator, but you and your opposing counsel are willing to continue to a second mediation session? Do you go back to that same mediator and try to educate them, or do you just try another mediator?
Depends on how well the mediator handled the first mediation. If I've got a mediator who lapses into the fact that they can divide by 2, I'm not real happy about that. I can divide by 2. I have very limited math skills, but I can divide by 2.
Thank God.
It's a miracle. I once had a room full of lawyers trying to multiply by 7. It was not going well. But seriously, I mean, I'm not going to come back if the mediator's not putting any creativity into it. I've had a couple of instances where I've had someone who decided they should mansplain my case to me. And I've decided I really didn't need that, and I didn't need to go back to that again. I have actually threatened to shoot the next mediator who says to me, Edith, juries really don't like lawyers. And that's actually not true. And if I'm going to resolve a case, it's not going to be because somebody's told me that juries don't like lawyers.
Very good. Okay.
It goes back. Some are good and some are bad for the case. And there's some people who are great arbitrators and not so great mediators. And if you get to a mediation and it's not going well and the person's not helping advance it, if you still want to go to mediation with the defense counsel, I usually call and say, hey, let's try somebody different.
Yeah.
I usually don't go to the same organization that person came from. I had to go to another organization. I just don't want to hurt their feelings, but on the other hand, you just have to say, look, your job is to do the best for your client, whether that's settling it or trying it. And if the impediment is the mediator, find another one. It's not like there aren't a lot of you out there.
That's right. Well, we've reached the end, but there are some questions. So I don't know, Hayward, if we have time, but before we take the questions, if we do have time, I want to thank you, Edith and Gretchen. You are fabulous. You are my heroes, mentors. I can't thank you enough. Thank you for being here and sharing so much knowledge and experience with all of us. And again, I want to thank Lucy, Barron, Hayward, and ADR Services for these educational webinars that are so instrumental in assisting attorneys and their clients resolve their cases, and for being the peacemakers of the world that we need many of.
Thank you again, presenters. That concludes our program. Everybody else, thank you for joining us today. As a reminder, your MCLA forms and the handouts will be emailed to you by the end of this week. We certainly hope you enjoyed the program.